Imagine finding out that your newest junior assistant, right, like someone who just started maybe 3 weeks ago, just legally bound your entire company to a $10 million commercial software purchase.
And you didn't sign a single contract.
Exactly. You never gave them permission to negotiate a purchase of that scale. You didn't even know they were talking to the vendor. But because, you gave them the title, Director of Procurement, in their email signature to make them feel good, the law says you have to pay that $10 million bill.
Yeah, and there is absolutely nothing you can do to stop it.
Welcome to the terrifying, completely invisible, and incredibly high-stakes world of agency law.
It really is the ultimate legal paradox, when you think about it. On one hand, it's this engine that makes the modern global economy possible. But on the other, it is a constant, lingering liability trap for anyone running a business or managing a team or, even just asking a friend to run an errand.
Which brings us to our mission today. Welcome to another deep dive. To you, the learner listening right now, whether you're prepping for a boardroom meeting or studying for a bar exam or just, listening on your commute, get ready. We are unpacking a really dense but wildly important stack of legal study materials today.
Very important.
Yes, specifically, we are diving into the Osmania University Law Program's curriculum. It's Unit 2 Special Contracts, and we're focusing our entire lens on the contract of agency exactly as it was laid down in the Indian Contract Act of 1872. That's sections 182 to 238.
And what's truly remarkable about this stack of sources is the historical context. We are looking at a legal framework drafted back in 1872.
Right.
Think about the world back then. We're talking about the era of the telegraph, steamships, the British Empire's massive mercantile expansion, yet the foundational rules that were drafted for merchants trading, like spices and textiles on the docks of Bombay, they're the exact same rules that seamlessly govern modern multinational corporate structures today.
It's what?
It is. Digital commerce, instantaneous global supply chains, the foresight in these provisions is just breathtaking.
It's basically the invisible connective tissue of our daily lives. Like, if agency law didn't exist, a modern corporation simply couldn't function. The CEO of a massive global logistics company would have to, personally fly to every single warehouse to hire every single forklift driver?
Exactly. They'd have to personally sign every diesel fuel receipt.
Right. Personally negotiate every delivery route. The entire modern world relies entirely on this legal magic trick of delegating authority.
Precisely. And our goal today is to look at the mechanics of that magic trick. We really need to understand how this relationship is born, the fierce loyalty the law demands once it exists, and, crucially, who takes the financial hit when things inevitably go disastrously wrong.
So let's unpack the core mechanism first. When we use the word agent in a legal context, we aren't talking about Hollywood talent agents, right, or secret spies. The Osmania University notes point us directly to Section 182 of the Indian Contract Act. It defines an agent as a person employed to do any act for another or to represent another in dealings with third persons. And the person for whom such act is done or who is represented is called the principal. So we are always looking at a triangle.
A triangle is the perfect way to visualize it. You have the principal at the top, the agent, and the third party. Historically, legal scholars have tried to describe the agent in a bunch of ways, but the most accurate way to understand their role is not as a separate person making a deal.
Okay, then what are they?
They are an extension of the principal. Think of the agent as a robotic arm operated by a remote control. The true test of whether someone is legally an agent is whether their actions have the power to bind the principal to that third party.
So meaning, if I give my friend $10 and say, hey, go buy me a sandwich from the deli down the street, I am the principal, my friend is the agent, and the deli owner is the third party. When my friend hands over the $10, legally, it's not my friend buying a sandwich and giving it to me.
Okay.
Legally, my friend is just the robotic arm. It's as if my hand reached out across town and gave the deli owner that money directly.
That is the exact mechanism. You have created a direct contractual relationship between yourself and the deli owner. Your friend, the agent, drops out of the legal equation entirely the moment that transaction is complete.
Wow.
And because the agent is wielding this incredible power, the power to bind you to an agreement you aren't physically present for, the law has established some incredibly strict rules about who actually possesses the legal capacity to build that bridge.
Which brings us to the concept of competency. because if I am handing over the remote control to my financial life, the sources get very specific about who can play these roles. Looking at the principal first, Section 183 says the principal must be competent to contract,
Right.
meaning they must be of the age of majority and they must be of sound mind.
And this is deeply rooted in the philosophy of consent. You cannot empower someone else to do something legally binding if you yourself do not possess the legal capacity to understand the consequences.
It makes sense.
If a person is, say, suffering from a severe cognitive impairment, they cannot legally sell their house. Therefore, they cannot sign a document authorizing an agent to sell their house. The stream cannot rise higher than its source, as they say.
Okay, that tracks logically. But here is where the source material threw me for a massive loop. Let's look at the competency of the agent under Section 184. The text explicitly states that the agent can be a minor,
Yes.
or even a person of unsound mind. Let's stress test this because it feels completely backwards to a layperson. I can send a 10-year-old child to negotiate a car purchase for me.
You can.
And if that child absolutely messes up the negotiation and agrees to a terrible, wildly inflated price, the 1872 law says the kid isn't personally liable. So as the adult principal, am I just legally trapped in whatever terrible deal my child agent just made?
You are entirely trapped.
That is nuts.
It sounds nuts, but to understand why, we have to look at how the law allocates risk. Remember that robotic arm analogy. The law views the agent merely as a conduit. The third party, the car dealership, is dealing with your authority, which just simply happens to be delivered by a child.
So the law is essentially saying you chose the faulty conduit, so you suffer the consequences.
That is the crux of it. The law's primary objective here is to protect the innocent third party. The car dealer entered into a contract in good faith, believing the child had your authority. The minor isn't forming the contract for themselves. Therefore, the minor doesn't need legal competency to bind you.
But wait, if an adult agent messes up my business, I can usually sue them for negligence, right? If my 10-year-old agent messes it up, what happens?
That is the crucial caveat in Section 184. While a minor can legally bind the principal to a third party, the minor cannot be held responsible to the principal for negligence, failure, or breach of duty. The law strips you of your right to sue the agent.
Meaning, I have to pay the car dealership the inflated price, and I can't even try to recover my losses from the 10-year-old who negotiated it. I just have to eat the loss.
Exactly. You assumed the entirety of the risk the moment you appointed a minor to handle a commercial transaction. The 1872 drafters were essentially telling merchants, look, we will facilitate your trade, but we will not protect you from your own absurd business decisions.
That paints a really vivid picture of risk allocation. It really hammers home that the agent's mind doesn't matter as much as the principal's power. Now, there's another element to this core concept that breaks a fundamental rule of contract law, right? Section 185, dealing with consideration.
Yes, this is a major departure from standard English common law.
Usually for any contract to be valid, there have to be a quid pro quo, an exchange of value. I give you money, you give me a car. If there's no consideration, the contract is void. But Section 185 explicitly states no consideration is necessary to create an agency. Why does the law enforce a free contract? Like if my neighbor promises to mow my lawn for free and he doesn't do it, I can't sue him for breach of contract because I didn't pay him. Why is agency different?
This requires us to look at the philosophical definition of detriment in contract law. Consideration isn't always about handing over cash, It's about taking on a legal burden or risk.
Okay.
When a principal agrees to be bound by the actions of an agent, the principal is taking on a massive, terrifying legal detriment. By giving the agent the power to alter your legal position, to spend your money, to sign away your rights, to bind you to a 10-year lease, you are placing yourself in a position of extreme vulnerability.
Oh, I see. So the sheer risk of handing over the remote control, that is the payment that makes the contract valid.
Precisely. That delegation of power forms the legal basis of the agency, regardless of whether a commission is being paid. The law recognizes that the relationship of trust and the assumption of liability is profound enough to warrant legal enforcement without a single rupee changing hands.
So we've established that the barrier to entry is almost non-existent. You don't need to pay the person, and the person doesn't even need to be a legally competent adult. With the threshold being that terrifyingly low, we need to understand exactly how this bridge is actually built in the real world. We don't want to accidentally hand over the remote control to our financial lives.
No, you definitely don't. And the Osmania University syllabus notes cite a classic 1913 case for this, P. Krishnabhatta v. Mandila Ganapathy Bhatta, to address this exact point. In this case, the courts had to determine whether a formal, stamped document was required to prove someone was acting as an agent.
And what did they decide?
The court's ruling was incredibly pragmatic. They held that no particular form of agreement is required. The creation of agency can be entirely consensual, incredibly informal, and sometimes completely unspoken.
The materials break down the specific modes of creation into categories, starting with the most secure, which is express agency. This is through spoken or written words.
Direct appointment. The clearest manifestation of this is a power of attorney. And in the commercial world, these are highly tailored instruments. You have general power of attorney, which is incredibly broad. An agent with a general PPOA might be able to manage your bank accounts, run your business, buy property in your name.
That sounds like giving someone the keys to your entire life.
It really is.
Yeah.
Which is why many prefer a special power of attorney, which limits the agent's authority to a single transaction, like maybe selling one specific piece of land in a specific city. And then you have a particular power of attorney, which might be as narrow as authorizing an agent to just stand in front of a registrar and present a single document for registration with no power to negotiate the terms of the document itself.
That's the clean, visible version. I say, be my agent, you say yes, and we write down the exact boundaries of your power. But the text immediately moves into the murky waters of implied agency. This arises from conduct, the situation, or the relationship between the parties. The notes use business partners as a prime example. Like, if you and I open a restaurant together, the law automatically implies that we are each other's agents for the ordinary course of the business.
Implied authority is where the law stops looking at what people wrote down and starts looking at how people are actually behaving in the marketplace. Let's look at the concept of ordinary course of business. If Lavanya lives in Mumbai but owns a textile shop in Delhi, and she puts Susan in charge of managing that shop, the law implies that Susan has the authority to do things necessary to run that shop.
Like what?
Susan can order inventory, hire a cleaner, pay the electricity bill, even if Lavanya never explicitly wrote those specific powers down in a contract.
But where does the implied authority end? If Susan decides the textile shop needs a delivery van, can she just go buy a $10,000 truck on Lavanya's credit?
That is exactly where the courts have to draw the line. Buying a delivery van might not be considered the ordinary course of managing a small textile shop unless they, already had a delivery service. The third party, the van dealership, has a duty to verify if an agent's implied authority stretches that far.
Okay, so implied agency is based on the actual relationship.
Yeah.
But then it gets infinitely more dangerous with agency by estoppel, or what the text also calls holding out.
This is perhaps the most critical concept for modern businesses to understand. Estoppel is a legal doctrine that essentially means you are legally prevented from denying a fact that your own previous actions established.
Right.
If you behave in a manner that leads third parties to believe someone is your agent and you don't step in to stop it, you cannot later claim they weren't your agent when the bill comes due.
Let me stretch out a hypothetical to see how deep this liability goes.
Yeah.
Let's say I own a wholesale bakery. I have a head baker who has been ordering flour from our supplier for 5 years. Everyone knows he's my guy. On a Friday afternoon, we have a massive argument, and I fire him. He hands over his keys and leaves. On Monday morning, that fired, disgruntled baker calls up the flour supplier, uses the bakery's account, and orders 50 massive sacks of flour to be delivered to his separate address, planning to steal them. The supplier delivers the flour, the baker vanishes, and the supplier sends me the invoice for thousands of dollars.
You are legally obligated to pay that invoice.
Even though he was no longer my employee. Even though he was actively stealing from me.
Yes, because you established an agency by holding out. For 5 years, you held this person out to the supplier as your agent. When you fired him, the burden was on you to notify the supplier that his authority was revoked.
Oh, wow.
Because you failed to correct the situation, you allowed the supplier to believe the agency still existed. The law will always protect the third party who acted in good faith based on your past conduct.
That implies a terrifying amount of liability for business owners. It means your legal exposure doesn't end just because a contract ends. It ends when the marketplace is made aware of it.
It is the single most dangerous area for modern corporate governance. Companies constantly accidentally create agents. Think about my earlier example of email signatures. A company gives a junior employee the title Director of Procurement simply to make them feel important. They don't give them any actual budget authority.
Right.
But that employee emails a vendor. The vendor sees the title. The title holds out to the world that this person has the authority to buy things for the company. If they sign a $1 million contract, the company might be bound by it purely by implication without a single official contract of agency ever being drafted.
So a vanity job title can literally bankrupt a company. That is an incredible aha moment. Okay, what about agency by necessity? The sources frame this as an exception to the rule that you need consent.
Necessity is the law's way of dealing with unforeseen emergencies. It allows someone to act as your agent without prior approval, but the bar is incredibly high. It must be an absolute necessity to protect your property from imminent loss, and it must be impossible to communicate with the principal to get instructions.
The classic example in mercantile law always involves ships and rotting cargo, right?
Exactly. Imagine a ship carrying a cargo of fresh tomatoes from India to England in 1880. A storm damages the ship, forcing it to dock in a random port in Africa for a month of repairs. The ship's captain knows the tomatoes will rot and become entirely worthless before they reach England.
And there's no telegraph.
Right, there is no telegraph line to contact the owner of the tomatoes. So the law grants the captain the implied authority by necessity to sell the tomatoes in that African port. The captain becomes the agent of the cargo owner by pure circumstance to mitigate the financial disaster.
It's the law stepping in to say, just do the common sense thing to save the value. But my absolute favorite mode of creation in these notes is the final one, agency by ratification.
Ratification is a fascinating legal mechanism. It is essentially the retroactive approval of an entirely unauthorized act.
Here is my analogy for ratification. Let's say a mid-level office manager takes the corporate credit card and buys a $5,000 luxury espresso machine for the break room. They have absolutely no authority to do this. It is a rogue purchase. The CEO walks into the break room the next day, sees the massive machine, and gets furious.
Naturally.
But before firing the manager, the CEO decides to try a cup of the espresso.
Yeah.
The CEO takes a sip, realizes it's the best coffee they've ever had, and says, actually, this is amazing. It stays. Good purchase. The CEO just ratified the agency. They took an unauthorized act and retroactively adopted it as their own.
That is a perfect illustration, and the moment the CEO ratifies the act, the legal relationship relates back to the moment the machine was purchased. It is as if the manager had the authority all along. But the Osmania University text notes some incredibly strict limitations on ratification.
Like what kind of limitations?
First, the principal must adopt the contract in its entirety. You cannot cherry-pick the good parts. In your example, the CEO can't say, we will keep the espresso machine, but I'm refusing to ratify the expensive monthly maintenance contract you signed with the vendor. If you ratify the machine, you ratify the whole deal.
You take the bitter with the sweet.
Exactly. Furthermore, ratification cannot be valid if it prejudices or unfairly harms a third party. You cannot retroactively approve an act if it strips a third party of a right they acquired in the meantime.
So, we've just established that you can accidentally give someone the power to bankrupt your company with an email signature or retroactively adopt a massive purchase over a cup of coffee. With the barrier to entry being that terrifyingly low, the law has to create a safety net for the principal. How does the law keep an agent from financially ruining the person they represent?
This brings us to the balancing act of rights and duties. Once the remote control is handed over, a very heavy burden falls onto the shoulders of the agent. The legal relationship here is fundamentally a fiduciary relationship.
Let's define fiduciary. It's a word that gets thrown around in finance deep dives a lot, but what does it mechanically mean under the 1872 Act?
A fiduciary relationship is one based on absolute trust, confidence, and a legally mandated selflessness. To borrow a visual analogy, taking on a fiduciary duty is like putting on a pair of specialized glasses. Once an agent puts these glasses on, they are legally blind to their own financial interests. They can only see the wealth, the benefit, and the interests of the principal.
The source materials outline the specific mechanical duties that enforce this blindness. First is the duty to act according to instructions. If I tell my stockbroker, sell my shares at $50, they cannot hold on to them, hoping the price goes to $60, even if they genuinely think they are doing me a favor.
And if there are no specific instructions, the agent must act according to the custom prevailing in that kind of business. A cotton broker in Mumbai must follow the established trading customs of the Mumbai cotton market.
Then there is Section 212, the duty to act with reasonable care, skill, and diligence. The notes say an agent is bound to conduct the business with as much skill as a person in his position ordinarily holds. How is this actually measured in court? What is the standard for reasonable care?
The courts use the reasonable professional standard. If you hire someone who holds themselves out to be a highly experienced commercial real estate broker, the court will judge their actions against what a hypothetical, competent commercial broker would have done in the same situation.
Right.
If the agent fails to notice a glaring zoning issue that any ordinary broker would have spotted, and you buy a worthless piece of land as a result, the agent has breached Section 212. They have to compensate you for the direct consequences of their sheer incompetence.
But the most sacred duties listed here are the fiduciary rules, the strict enforcement of loyalty. The agent must maintain total confidentiality. They must never set up an adverse title, meaning if I give my agent a property to manage, the agent can't suddenly fabricate documents claiming the property actually belongs to them or a third party. And crucially, there is the absolute rule against secret profits.
The rule against secret profits is the bedrock of agency law. There can be no kickbacks, no side deals, no conflicts of interest.
Let's stress test the secret profit rule. Let's say you hire me to buy a commercial building for your business.
Right.
My budget is $2 million. I go out searching. My brother happens to own a commercial building that fits your needs perfectly.
Okay.
He probably tells me, hey, if you get your client to buy my building for the full $2 million, I'll secretly give you a $50,000 finder's fee under the table. The building is genuinely worth $2 million. You get exactly what you wanted at a fair market price. But I take the secret 50 grand from my brother. Since you didn't lose any money on the fair market value, is that a breach?
It is a profound breach of fiduciary duty. It does not matter if the principal suffered a direct financial loss or if the deal was at fair market value. The moment you accepted a side deal, you took off those fiduciary glasses. You allowed your personal interest to conflict with your duty.
Wow.
If the principal discovers this, the law allows them to demand that you hand over that $50,000 secret profit entirely to them. The agent cannot make a single cent off the agency other than their agreed-upon remuneration.
Which perfectly transitions us to the reward side of the equation.
Right.
Because it can't be all burden and no benefit. The law has to incentivize people to actually act as agents. First and foremost, the agent's right to remuneration. The source cites the historical 1803 case of Headley v. Bainbridge.
This case is foundational because it established the baseline expectations of commercial agency long before the 1872 Act was codified. The ruling essentially stated that unless there is an agreement to work for free, the law implies a promise to pay the agent once the act is completed. If no specific fee was fixed in advance, the agent is entitled to reasonable compensation based on industry standards.
They also have the right of retainer. This means they can hold on to the principal's funds that legitimately come into their possession. Like, if I collect rent for you, I can keep enough of that cash to cover my own property management commission and any lawful expenses I incurred fixing the plumbing before I hand the rest of the cash over to you.
And critically, the right to indemnification. If the agent is carrying out lawful acts on behalf of the principal and a third party sues the agent, the principal has to step in, cover the legal costs, and pay any damages. The principal must shield the agent.
But the notes highlight a very specific, fascinating exception to indemnification. The principal is never bound to indemnify the agent against criminal acts, even if the principal expressly ordered the agent to commit the crime.
Exactly. Let's say you are a fiercely competitive business owner. You instruct your agent to go to a rival's warehouse and physically assault their manager to intimidate them. The agent follows your instructions, punches the manager, and gets sued for assault and battery.
Right.
The agent cannot turn to you and demand indemnification for their legal fees. The law will not enforce a contract that requires someone to underwrite a crime. The agent is entirely on their own.
Good to know. But I want to push back on one specific right listed in these materials that feels incredibly aggressive. The right of lien. The notes say a lien is the right to retain possession of the principal's goods, papers, or property until the agent's commission is paid. If my real estate agent isn't paid their commission, they can legally just hold the title deeds or the keys to my house hostage. Isn't that basically extortion?
It sounds severe to modern ears, doesn't it? But we have to look at the economic philosophy of the 1872 Act. The right of lien is a mechanism designed to balance a massive power dynamic inherent in early commercial trade.
How does holding my property hostage balance the scales?
Think about it from the agent's perspective. The law has stripped the agent of their autonomy. It demands absolute, unwavering fiduciary loyalty. They cannot make secret profits. They must put your interests above their own. Often, these agents are spending their own time and resources to facilitate deals for incredibly wealthy principals, merchants, aristocrats, large corporations. In return for stripping the agent of their ability to hustle for themselves, the law grants them this heavy-handed tool, the lien.
Oh, so it's a built-in insurance policy.
Exactly. It ensures that an agent isn't left entirely at the mercy of a powerful principal who simply refuses to pay the bill. The lien is the agent's ultimate leverage. It guarantees they're compensated for their legally mandated loyalty.
Okay, when you frame it as a counterweight to the fiduciary duty, it makes mechanical sense. Now, if an agent has all these strict duties, especially the duty under Section 212 to exercise personal skill and diligence, it begs a very practical, everyday business question. If I hire a highly skilled agent, can that agent just turn around and hire someone else to do the heavy lifting?
This is a major issue in the law of agency, and it revolves around a famous Latin maxim, delegatus non potest delegare. A delegate cannot further delegate. Section 190 of the Indian Contract Act codifies this principle.
A delegate cannot further delegate, meaning I picked you for your specific skills, your specific judgment, your specific character. You cannot farm out that responsibility to a stranger.
The relationship is built on personal trust. It would be an absurd violation of that trust if you hired a world-renowned, highly specialized art dealer to travel to Paris and buy a specific painting for you, and the art dealer just delegated the task to their inexperienced teenage nephew who happened to be on vacation in France. You didn't hire the nephew, you hired the expert.
But the global business world would instantly grind to a halt if nobody could ever delegate anything. The CEO of a multinational bank is technically an agent of the shareholders. If the CEO can't delegate, the bank collapses in 5 minutes. There have to be exceptions.
And there are. The source materials outline several practical exceptions to the rule against delegation. The first is implied permission. In large corporations, it is simply understood and implied by the sheer scale of the operation that agents will work through massive hierarchies of subordinates.
The notes also mention the custom of trade. For example, stockbrokers or auctioneers. It is standard industry practice for a lead auctioneer to use assistants to catalog items, process bids, and handle the paperwork. And of course, unforeseen emergencies, which ties back to our necessity discussion. If the agent gets into a severe car crash on the way to sign a crucial, time-sensitive contract, they might have emergency authority to delegate the physical act of signing to a subordinate.
There is also a very clear exception for purely ministerial or clerical acts. If the task does not involve any professional discretion, judgment, or specialized skill, like simply dropping a signed contract into a mailbox or typing up a dictated letter, the agent is free to delegate that.
Okay, let's explore a scenario where delegation is legally allowed. The Osmania University material spends a significant amount of time and provides a very detailed comparison table distinguishing between two types of delegated agents, a subagent under Section 191 and a substituted agent. To a layman, those sound like two different words for the exact same thing.
They sound similar, but legally the mechanical distinction is profound. And it all comes down to a foundational legal concept called privity of contract.
Let's deep dive into privity of contract first because it's a term that haunts law students.
Privity of contract is essentially a legal bubble. The rule states that only the actual parties who entered into an agreement exist inside this bubble. Only the people inside the bubble can sue or be sued on the terms of that contract. If you and I sign a contract for me to paint your house, a random neighbor walking down the street cannot sue me for doing a bad job because the neighbor has no privity with us. They are outside the bubble.
Got it. So how does the bubble apply to subagents versus substituted agents?
Let's look at the subagent first. According to Section 191, a subagent is a person employed by and acting under the direct control of the original agent. The original agent is completely responsible for their actions. Most importantly, the principal and the subagent are not in the same legal bubble. There's absolutely no privity of contract between the principal and the subagent.
Let me build an analogy to visualize this. A subagent is like a general contractor hiring a plumber. I am the principal. I hire a general contractor, my agent, to build my house. We have privity. The contractor then hires a plumber to install the pipes. The plumber is the subagent. If the plumber does a terrible job, the pipe bursts, and my new house floods. I don't sue the plumber. I have no contract with the plumber. We share no privity. I sue my general contractor because the contractor is the one inside my bubble, and they're responsible for the subagent's work.
That is a brilliant mechanical analogy, yes. The principal sues the agent, and then the agent can turn around and sue the subagent. The original agent acts as an unbreachable wall between the principal and the subagent.
Okay, so how does a substituted agent alter the bubble?
A substituted agent is someone who is named or selected by the original agent, but who ultimately works directly under the control of the principal. The original agent essentially says, I cannot fulfill this specific task, but here is a professional who can. The principal agrees, and at that moment, the original agent drops out of the equation entirely.
Wow, biggest leaf.
Yes, a new bubble is formed. A new direct privity of contract is established between the principal and the substituted agent.
Continuing my house building analogy, a substituted agent is when I hire my general contractor, and the contractor looks at the blueprints and says, look, I actually don't do complex copper plumbing at all. I shouldn't touch this.
Yeah.
But here's the business card for an excellent independent master plumber. You should hire them directly.
Yes.
If I agree, and I hire that master plumber and the pipe bursts, I cannot sue my general contractor. The contractor just made an introduction. I have to sue the master plumber directly because the plumber is a substituted agent and we are now inside a new privity bubble together.
Exactly. And the reason this distinction is so heavily tested in law schools and so heavily litigated in corporate law is because it answers the ultimate question: who takes the financial hit when things go disastrously wrong?
Who is left holding the bag?
Precisely. In a sub-agency, the original agent is left holding the bag for the mistakes of their subordinates. In a substituted agency, the original agent washes their hands of the liability entirely, and the principal must deal directly with the substituted agent.
Let me stress test this. What if my general contractor wants to wash his hands of the liability and tries to force a substituted agency, but I don't want to deal with the plumber directly? Can the agent unilaterally create a substituted agency just to avoid risk?
No. The creation of a substituted agency requires the express or implied consent of the principal. The principal has to agree to bring this new person into their privity bubble. An agent cannot simply abandon their liability without the principal's permission.
This concept of who takes the hit is exactly what third parties in the marketplace care about. When the agent steps out of the corporate office and into the market to sign deals, the vendors, the suppliers, and the banks want to know exactly whose money is on the line. Which brings us to the complexities of personal liability and third parties.
This brings us to Section 230 of the Act, and it establishes a very clear foundational general rule. An agent has no personal liability.
Not at all.
As a general rule, no. In the absence of a contract specifically stating otherwise, an agent cannot personally enforce contracts they enter into on behalf of the principal, nor can they be personally sued for breaching them. They are just the remote control arm. You don't sue the robotic arm for the actions of the person holding the controller. The agent enjoys a powerful shield of personal immunity.
But knowing the law, there must be a laundry list of exceptions to this shield. The law won't let people cause chaos and just shrug their shoulders.
There is a very robust list of exceptions where the shield is pierced and the agent does become personally liable. Some are quite logical. For example, if the agent expressly agrees in the contract to be personally liable as a cosigner, they are.
Makes sense.
Or if an agent signs a commercial document like a promissory note or a check in their own name without making it explicitly clear on the document that they are acting solely as an agent, the law will hold them personally liable as the maker of that note.
That makes perfect sense. If you sign your own name without a disclaimer, you take your own risk. The notes also mention an exception for a foreign principal.
Yes. Where a contract is made by an agent for the sale or purchase of goods for a merchant resident abroad. Again, we must look at the 1872 context. Imagine a local supplier in Bombay providing tons of raw cotton to an agent representing a textile mill in Manchester, England.
No.
If the mill in England refused to pay, pursuing a lawsuit across the oceans in 1872 was incredibly difficult, prohibitively expensive, and often impossible. To protect local businesses and keep local commerce flowing, the law stripped the agent of their immunity. It made the local agent personally liable for the debts of their foreign principals.
Another exception is if the principal is incompetent, which ties back to our earlier discussion about the minor. If an adult agent acts for a 10-year-old principal, the agent might be held personally liable because the third party cannot legally sue the minor. The law ensures the third party has someone to sue to recover their losses.
Exactly. But there is also Section 238 dealing with torts and fraud, which creates massive exposure for the principal. If the agent commits fraud or misrepresentation during the course of the principal's business, the principal is liable for it, as if the principal committed the fraud themselves.
Wait, if the agent lies to close a deal, the principal gets sued for fraud.
Yes. provided the lie occurred within the scope of the business. The principal chose the agent, the principal deployed them into the market. Therefore, the principal bears the risk of the agent's fraudulent tactics. However, if the agent commits fraud in matters entirely outside the scope of their authority, say, a delivery driver commits real estate fraud on his route, then the agent is personally liable, and it does not affect the principal.
The boundaries of authority are everything. But there is one concept in this section that I found absolutely mind-boggling. It's the concept of the undisclosed principal.
Ah, yes, Section 233. This is one of the most mechanically complex and fascinating areas of agency law. It represents a historical tension between strict English common law and mercantile expediency.
Let me set this up for the listener, because here's where the legal mechanics get truly wild. An undisclosed principal scenario is where an agent goes out into the market and negotiates a contract, and the third party thinks they're just dealing with the agent as an individual. The agent appears to be acting entirely in their own personal capacity. But in reality, they are secretly acting on behalf of a principal that the third party knows absolutely nothing about.
Correct. The third party has no idea the robotic arm is a robotic arm. They think it's an independent human being making a deal for themselves.
And the 1872 Act says this is completely valid. The undisclosed principal has the legal right to suddenly step out of the shadows, intervene, and enforce the contract against the third party. I have a real problem with this. Isn't this basically institutionalized deception?
It can feel that way.
I mean, I'm entering a contract without knowing who the actual counterparty is. That feels like a violation of basic market fairness and consent.
I completely understand the discomfort, but we have to look at why the law allows this. The law prioritizes commercial stability and the fluid movement of capital over absolute transparency. Let's say a major corporation wants to assemble a massive tract of land to build a factory. If they announce their identity, every landowner will instantly quadruple their asking price.
True.
By using undisclosed agents, the corporation can acquire the land at fair market value. The law views this as a legitimate commercial tactic. As long as the agent had the authority to buy the land, and the contract itself was lawful and the price was paid, the market requires the transaction to be upheld. If contracts could be torn up simply because one party didn't like the true identity of the buyer, commercial real estate and corporate acquisitions would collapse.
So market efficiency trumps total transparency.
Yes, but the law does provide crucial safeguards to protect the third party from true unfairness. First, if the contract expressly or by clear implication excludes the possibility of an undisclosed principal, then the principal cannot intervene. More importantly, if the identity of the agent was the absolute fundamental reason the contract was signed, say, you were hiring a specific famous painter to paint a portrait because of their unique artistic skill, that painter cannot secretly be acting as an agent for a lesser-known artist. The personal skill is the essence of the contract.
Okay, but what happens if the undisclosed principal breaches the contract? Let's say the agent signs a deal to buy 50 tractors from me, and then the newly revealed massive corporate principal refuses to pay the invoice. Who do I sue? Does the agent suddenly get to use their immunity shield and point at the corporation?
This is the genius of Section 233's Balancing Act. Once the principal is disclosed, the third party you gets to choose your target. You can sue the agent personally, holding them to the illusion they created. Or you can sue the newly discovered corporate principal. Or you can sue both. The liability becomes joint and several.
That's reassuring.
The law punishes the agent for the secrecy by stripping away their usual immunity, making them personally liable, while also allowing you to go after the deep pockets of the actual principal.
That makes me feel a lot better about the fairness of the rule. You can hold the agent's feet to the fire for their omission. So at all these heavy liabilities, the potential for being sued for your agent's fraud. These secret undisclosed principles. It sounds incredibly stressful for everyone involved. No one wants to stay in an agency relationship forever. So how do we pull the plug? How does it all end? Let's look at the final piece of the puzzle, cutting the cord, termination of agency.
Just like creating an agency, terminating one can happen in several distinct ways. The Osmania sources divide termination into two main categories, by act of the parties and by operation of law.
Act of the parties seems straightforward. The first one is mutual agreement. We both agree to start it. We both agree to end it. Clean, simple, no drama.
Then there is unilateral revocation by the principal. The principal simply exercises their power and says, you are no longer my agent. The remote control is turned off. Or conversely, renunciation by the agent, where the agent simply quits.
But the notes have a massive red flag regarding unilateral revocation. A principal can revoke authority, But if they do it wrongfully, without giving reasonable notice, they have to pay compensation to the agent. You can't just fire your commercial real estate agent 5 minutes before they finally close a massive deal they've been working on for a year, purely to avoid paying their commission.
Exactly. The law protects the agent from being abused or exploited. The courts will look at whether the revocation was an attempt to defraud the agent of their rightful earnings. And then we have termination by operation of law. This is where the agency ends automatically, regardless of what the principal or the agent actually want.
The first one under this category is obvious: completion of the business. If I hire you to sell my car, and you sell the car, hand over the keys and give me the money, the agency is over. There is nothing left for the conduit to do, or expiration of time.
Hmm.
If you are appointed as my agent explicitly for the month of June, on July 1st, your authority vanishes into thin air.
Death or insanity of either the principal or the agent also instantly terminates the agency by operation of law. A dead person cannot have an agent acting on their behalf in the living commercial world because the principal no longer possesses the capacity to be bound. Insolvency or bankruptcy of the principal also terminates it automatically.
Why bankruptcy?
When a principal goes bankrupt, they lose legal control over their own assets. The courts and creditors take over. Therefore, their agent can no longer make deals regarding those assets.
And the destruction of the subject matter. If I hire you to sell my coastal warehouse, and a hurricane wipes the warehouse off the map, the agency is terminated because there is literally nothing left to sell. The purpose of the agency has evaporated.
But there is one incredibly nuanced, powerful exception to termination that we absolutely must discuss. It is found in Section 202, agency coupled with an interest.
Agency coupled with an interest. What does that mechanically mean?
It means that the agent isn't just a neutral third party working for a commission. It means the agent has a personal, special, or direct beneficial interest in the actual property that forms the subject matter of the agency.
Walk me through a scenario where this happens.
Let's say you owe me $50,000 from a past business deal. You don't have the cash to pay me back, but you do own a piece of undeveloped land. So, we make an agreement. You appoint me as your legal agent to sell that land, with the express written agreement that when the land sells, I can keep $50,000 from the sale proceeds to clear your debt to me, and I will give you whatever cash is left over.
Okay.
In this scenario, I am not just your agent. I have a direct, legally recognized financial interest in the property itself being sold. My recovery of my debt is tied directly to the execution of the agency.
Okay, I see the setup. You are my agent, but you are also my creditor, and the agency is the mechanism to get your money. What happens if I suddenly get cold feet, or I find a way to pay you back differently, and I decide to revoke your agency before you sell the land? Can I just turn off the remote control?
Under Section 202, you absolutely cannot. If an agency is coupled with an interest, the principal is legally barred from terminating the agency to the prejudice of the agent's interest. The law treats this not just as an agency, but as a form of security for the debt. Furthermore, this type of agency is so robust that it does not even terminate if the principal dies or goes insane. The agency survives, binding the principal's estate, until the agent's financial interest is fully satisfied.
That is staggering.
Yeah.
So you can't just fire your agent if they essentially own a piece of the outcome. It's like trying to fire your business partner by just changing the locks on the office door. The law simply won't let you do it. The agent has a legally protected right to see the transaction through to the end.
It is perhaps the finest example of the 1872 Act perfectly balancing the scales of justice and commerce. It prevents a principal from using the mechanism of agency termination to essentially defraud a creditor or strip an agent of their secured rights.
This has been an incredibly illuminating journey. We've taken a massive, dense syllabus on the Indian Contract Act's rules of agency, and we've really explored the deep mechanics of how it governs our world. Let's do a quick wrap-up of the ecosystem we've uncovered.
Sounds good.
We started by learning that an agent is simply a conduit, a robotic arm, connecting a principal to a third party, and that even a minor can operate that arm because they aren't the ones absorbing the liability. The principal is. We learned that this terrifying bond can be created formally with a highly specific power of attorney, or entirely by accident through a casual email signature in an agency by estoppel, or even retroactively ratified over a cup of break-room espresso. Once created, the agent must put on the fiduciary glasses. No secret profits, no side deals, absolute loyalty. But they are rewarded with the right to be paid, indemnified against lawsuits, and even the right to hold the principal's property hostage, the right of lien, if they are stiffed on their commission. We explored the rigid rule of delegatus non potest delegate, a delegate cannot delegate, and saw how the difference between a subagent and a substituted agent dictates exactly whose privity bubble pops when a project goes disastrously wrong.
Beautifully summarized.
We saw that while agents usually enjoy an impenetrable shield of personal immunity, the law will aggressively shatter that shield if the agent acts for a foreign principal, an incompetent principal, or a secretly undisclosed corporate giant. And finally, we learned that the whole relationship can be terminated at any time or instantly dissolved by death or disaster, unless the agent happens to have a personal financial interest firmly anchored in the deal.
It is a brilliantly engineered ecosystem of trust, power, and accountability. It protects the principal from rogue agents, it protects hardworking agents from deadbeat principals, and most importantly, it protects the innocent public marketplace from both of them.
To you, the learner, I want you to remember this the next time you step into the commercial world.
Mm.
Whether you are just signing for a package on behalf of your roommate, or you are an executive negotiating a multi-million-dollar corporate merger, you are an active player in the game of agency. The invisible strings of these 1872 laws are attached to almost every single transaction you make.
And if I may leave our listeners with one final provocative puzzle to mull over. Throughout this entire deep dive, we have talked exclusively about humans. We've talked about the minds of adults, the legal age of majority, and the requirement of a sound mind. But think about the reality of the global market today. High-frequency trading algorithms, automated supply chain software, and AI bots make thousands of financial transactions on our behalf every single microsecond. If a piece of code or a smart assistant automatically negotiates a bad supply deal for your business based on an algorithm, does that code have implied authority? How does a mercantile law written in 1872 apply when your active agent has no human mind at all, sound or otherwise, but still legally binds you to $1 million loss? Think about the implications of that the next time you let an AI assistant autonomously reorder your groceries or manage your stock portfolio.
Suddenly, that messy, murky legal landscape we talked about at the beginning feels even darker and infinitely more complex. We aren't just looking at the robotic arm of a human agent anymore. We're trying to figure out who pays the bill when the robotic arm starts thinking for itself. Thank you for joining us on this deep dive.